Welcome to the VeriDAO channel. I am Lisa Davis, and today we have Nick Morgan from ICANN with us to talk about the amicus briefs that are being filed in the SEC versus Ripple case. Be right back right after this. Welcome to the VeriDAO channel. We've got Nick Morgan, Trey Cup, and the one and only Reggie Middleton with us here today.
Good morning, Lisa.
Good morning. Thank you guys all for joining me. We have a lot going on in the case. I believe there's been 16 amicus filed. And Nick, thanks for joining us. You've been just a warrior in this fight for the people. And can you, I know you're a former SEC attorney, you're also a private attorney with the Paul Hastings Group. And can you kind of tell us your journey and how you got involved with ICANN and what your role is up to this point?
Yeah, happy to, Lisa, and thank you so much for having me. So as you mentioned, I used to work for the SEC in the enforcement division and specifically the trial unit. So I would litigate cases in court that had been investigated by the enforcement staff. And then quite a while ago, I left the SEC and went into the private sector, into a private law firm. And I'm now at the law firm of Paul Hastings, which is a multinational firm that does all kinds of things, including what I do, which is primarily SEC defense. So for the last 17 years in the private law firm setting, I have been representing people who have been involved in SEC investigations, in SEC litigation and trials. And so partly as a result of that, I've had kind of a front row seat for some of what doesn't work with the SEC and the way the SEC goes about regulating the securities markets. So for example, my firm's a big firm. We're relatively expensive. Not everybody can afford to hire a big law firm when they're being investigated by the SEC. Even if they haven't done anything wrong, they may have a good defense or good points they want to make with the SEC, but not everyone can afford counsel. And so at the private law firm, we get approached by people all the time who unfortunately we can't represent. And what happens in those situations is the SEC wins. The SEC decides it wants to bring a case, the enforcement division. People can't afford to defend themselves, and so people end up settling with the SEC. A vast majority of SEC cases in any subject area get settled. Virtually no one litigates against the SEC. So we watch that in a private law firm setting and realize that that's not the way things should go. And what ends up happening, because the SEC settles most of its cases, and we see this in the digital asset space specifically, but it happens in all subject matters, is the SEC accumulates very slowly, case by case, a body of what they view to be the law, even though no courts are generally involved because these are all settled matters. So they don't go to trial. There's no judge or jury that weighs in. So you get this accumulation of settled cases that the SEC views to be the body of law. And it's a pro-SEC body of law because they're settling these based on their allegations without having to prove things up. So ICANN is the sort of was born out of witnessing this process. And ICANN is the Investor Choice Advocates Network. It's a 501c3 nonprofit. We started it almost a year ago, so we're just under a year old. We're still a fledgling organization. But the idea was twofold. One, to represent people who can't afford counsel in SEC matters. It requires a specific skill set to be able to do that, and not everyone can afford it. Oh, thanks. And so that's the first part. And we're because we're brand new, we don't yet have the resources to take on direct representation in an SEC litigation. That's pretty resource intensive. So we hope to be in that position next year. But the second thing we wanted to do was to represent people in cases where precedents are being set. So right now, a lot of the precedents are being set in the digital asset space, but there are certainly other subject matters where that's also true. And when these precedents get set in a pro-SEC fashion, over time, these regulatory barriers to entry into the capital markets go up. And that mostly impacts people who are not traditionally represented in those capital markets. So minority communities, people who want to break in, disruptors, new entrants to the markets have a tough time getting in because the regulatory barriers are high. So we're really looking to represent people in cases where we can lower those barriers so that more people can enjoy the benefits of our capital markets, which are pretty fantastic. So that's the mission of ICANN, and where my history at the SEC fits into it.
Amazing. Well, that really does dovetail with the mission of Veritasium. I know there's so much similarity, and really exciting to see, even though it's through adversity, this community come together. And you reached out to us, and just being able to see this community come together and reaching out for the little guy. I'm just having a thought about when you said how the SEC brings together all this body of work without it ever really getting to the courts. Wouldn't that be a violation of constitutional rights as well? Because then decisions are made without ever being viewed in, in someone's a jury of their peers.
Yeah, it could be. I mean, unfortunately, because it's so expensive to defend oneself in an SEC matter, people consent to these settlements. And so they're doing it voluntarily. They're faced with the alternative of financial ruin in defending themselves or settling. So whether that
Reggie might know something about that.
What to say on that?
Sounds like you redefine the word voluntarily, but I'm going to fade back and allow you to finish. Go ahead.
Yeah. No, I mean, your point, I think where you're going, Reggie, probably is it really voluntary if you're, it's a, what they call a Hobson's choice, financial ruin or consent to these things. And that unfairness is really what gave birth to ICANN. Like there is no, because the SEC brings only civil cases, not criminal, there's no constitutional right to counsel in civil matters. So there is no, for example, there's no right to federal defender counsel that would be provided for by the government. So people are on their own. So it can raise constitutional questions, Lisa, in response to the comment you were making, but by and large, people are voluntarily, in quotes, Reggie, consenting to these settlements, and so they've given up their ability to challenge things on a constitutional level. Unless you're Ripple, in which case you can afford counsel and attract the interest of others, which we both have submitted amicus briefs in that case.
Reggie, I've heard you say this before, and I thought it was really interesting reading the mission statement of ICANN, that they wanted to bring capital markets to those that didn't have access to it or couldn't afford to get access to it. Could you describe that as one of the tenets of creating the Veritasium platform in the first place?
Right. The platform is essentially a programmatic peer-to-peer capital markets, or programmatic capital markets that allow access to anybody who has a computing device, primarily a cell phone or up, and access to the internet. That low barrier destroys the business models of practically the entire Wall Street or High Street apparatus. That's London, New York. But in doing that, it releases significant dynamic energy. Most of the intellectual capital, most of the creativity resides in the individuals, yet the vast majority of individuals sit outside of that apparatus. 0.009% of society lives within that apparatus, while everything else lives without it. So imagine if you can get all of the creativity and the brain power of everybody into the capital markets. There'll be true markets. So the 11-year-old girl in Sri Lanka who knows wheat trading and wheat growth cycles, a multitude better than your typical Goldman Sachs trader can participate, albeit at a lower level of capital. But if she wants to capital up, she can get others throughout Sri Lanka, Bangladesh, Pakistan team up with that 5-year-old or 15-year-old wonderkind in Abuja, Nigeria, and that 16-year-old in Idaho. And they all trade against Goldman Sachs. Win or lose, it's irrelevant as long as access is egalitarian. Okay, now a lot of people push against that when they hear the word egalitarian or equal, but I'm not pushing for equal outcomes. I'm pushing for equal access. Equal access will invariably have unequal outcomes, but that's also called a market. When you have unequal access, you are forcing equal outcomes where those who are already at the top remain on their top, and those who aren't at the top never get a chance to get up there. So think of the Darwinian theory inverse, and that's what the capital markets are now, from my perspective. That's a very long-winded way of saying just equal access, but I talk a lot. So.
That is so great to hear. Sorry, Trey, I didn't mean to cut you off, but it's
Go ahead, Nick.
So what after we filed the Ripple amicus brief, the next ICANN project was to petition the SEC to lower the financial restrictions on accredited investors. I don't know how familiar you are with the accredited investor definition, but it keeps a lot of entry-level investors out of the markets based on their lack of capital. So if you don't have capital, you're never going to get it. And so I just think with what Reggie just said, it really dovetails nicely with ICANN's next project, which was this accredited investor rule petition, which is also on the website if anyone wants to read it.
Yeah, I would posit that there should be no capital requirements for accredited investor. The accredited investor should be based upon knowledge and not capital. Okay, so you have $100 of net worth, then if you fill out a net worth statement, you can wager no more than 5% or 10% of that net worth. So there is no capital requirement. You can have a percentage of net worth requirement, but to have a net worth requirement is discriminatory on its face. And as you said, it's to make sure that the rich stay rich and the poor stay poor. There's no way in the world you can earn your way to wealth. It is absolutely impossible. And you can't study your way to wealth academically. The only way to be wealthy is to participate in the wealth generating capital markets. And if you put a barrier there, and that barrier is capital driven, only fast people get to run in the race.
Exactly. You just paraphrased our rule petition, right? That's exactly the point we made. And we went around and gathered up video statements from different people who are in favor of lowering or eliminating those financial restrictions on the accredited investor definition. So we talked to Brittany Davis at Backstage Capital. We talked to Ramona Ortega. She has My Money, My Choice. And so there are a lot of people out there at like a grassroots level who are in favor of eliminating those restrictions for exactly the reason you just articulated.
Flip that to the inverse. Imagine if you had a knowledge and capability restriction to enter into crypto.
Right.
There'd be about 4 of us here.
Right. That's funny.
Yeah.
So, Nick, I wanted to get your thoughts on the digital asset space in general, if you could, because it seems like you have a wealth of experience and knowledge about how the SEC works. The VeriDAO has been kind of fighting the good fight ever since the SEC came against Middleton and Veritasium back in 2019. We hold a token. We don't know what we hold at this moment because the SEC has been unwilling to tell us exactly what we hold and how we can use it. We've gone into very lengthy steps to ask for FOIA requests, which are communications between us and the SEC, which they've conveniently lost. We filed a no action letter through representation with Jeremy Hogan, where they didn't give us a response, but they gave Jeremy a 40-minute consult with 4 attorneys from the enforcement side of the SEC, not the regulatory side. And yeah, and basically what they did was they shook their finger at us as Veritasium holders and said, you Mr. Hogan, you tell your clients that they shouldn't be dealing with that token whatsoever. It's an unregulated security. which, in the settlement between Middleton and the SEC, they didn't define what a security was anywhere in the whole document. And my question is, how does the SEC, where there's really no codified law, come in and start regulating a space when really the only body that's has the authority to regulate the space is the court system? Am I right there?
Well, yeah, sort of. And I don't want to sound like an apologist for the SEC, because I think they have acted aggressively, to put it mildly, in this space. But so Congress, and apologize telling people what they already know, but Congress passes laws. And we've got the Securities Act of 1933 and the Securities Exchange Act of 1934 are the primary laws we're dealing with here. And they speak broadly and generally, not specifically. So, for example, in the 33 Act, if you want to go look up the definition of a security, you can. And there's a list. Stocks are securities, certain bonds are securities, and it's a pretty long list. And on that list is a vague term, and this goes to the point we made in our amicus brief in the Ripple case. One of the terms is investment contract. Well, what does that mean? It's not really clear. So, of course, as we all know now, the Supreme Court in the Howey case in 1946 said an investment contract has these characteristics. Somewhat helpful, not super helpful. So the SEC encounters something new that it's never seen before, which is what's been happening in the digital asset space and will continue to happen as people innovate and come up with new things. And they have to decide what to do. And you're right that when the SEC takes a position on whether a particular token is a security, that is just the SEC's view. And it's entirely possible that a court, which would be the final arbiter, would disagree with the SEC. And we saw that, for example, I don't know if you remember the token called hashlets, but in the hashlets case, it was one of the many matters that the SEC brought. They settled with the issuers of the hashlets token. And in that settlement, they said, these tokens are securities. Then there was a separate private lawsuit that didn't involve the SEC that went all the way to a jury. And the jury decided, oh, hashlets are not securities. So you've got two competing outcomes there, one where it's settled with the SEC and one where it's litigated and goes to a jury. But your question, Trey, was how can
I have a question, if you don't mind me asking.
Not at all.
Is it private suit in federal court or state court?
Federal court, my recollection. Yeah.
Okay, so shouldn't the federal decision by a judge and jury supersede that of a settlement in terms of precedent?
You would think so, or one might think so. But the SEC is under no obligation to go back and undo its settlement, and in fact, they didn't undo their settlement. So what you've got are two different bodies reaching two different conclusions as to the same token and whether it's a security.
But the settlement doesn't count as case law, though, correct?
No, it doesn't. It is what I would call sort of soft precedent. Like the SEC can't take the settlement and go into a different case and say, aha, because we settled this matter, you judge in this other case must conclude the same way. So right. It's soft.
Could you take that jury's deliberation back to the original judge in the settlement case and say, Mrs. Judge or Mr. Judge, the jury of our peers have determined that it's not a security. Would you consider looking at this case and giving a declarative judgment?
You could try that, but when you settled your case with the SEC, you've given up most of your rights to go do that. So to come back in front of that judge, the judge said, well, why are you in front of me now? You already gave up all those rights. Like, we're done. So
here's the fun part. I don't want to jump in. Here's the fun part. So if it could be shown that the settlement was done under duress, or more importantly, that the SEC used dirty hands, then you have the opportunity to go back, correct?
Yeah, you could probably get the judge to reopen the case, in which case you'd be litigating, and you would say, Judge, here was this jury that reached a decision in another case in which the SEC was not a party. That is also not binding precedent in the SEC case. So if you were able to show duress or somehow get the judge in the SEC case to reopen the case, you would be litigating it, and you would certainly point out that a jury reached another different decision in a different case, but your judge in the SEC case would not be bound by the decision in the other case. So frustratingly, what ends up happening is when the SEC's enforcement division has something new digital asset it's encountering for the first time, it doesn't know what a jury would do or a judge would do. Its only way to find out, like our way to find out whether it's a security, is to file a lawsuit. That's how you get a judge or a jury to decide. And so the SEC does have the jurisdiction to bring a lawsuit when they think it's a security, but no judge or jury has ruled that it's a security yet. So it's sort of a chicken and egg problem. How do you find out how litigating?
So I'd love to jump in on that because,
yeah,
with all due respect, I disagree. The sitting chairman of the SEC has admitted on video multiple times, as in 2 times or more, that they only bring cases against those entities where they feel they can win from a resource perspective.
Right.
He's already said, whether he should have said it or not, it's irrelevant. He has said it, that the reason why they don't go after the Wall Street banks is because the Wall Street banks above a certain fine amount will push back. And they have a strong proclivity to win, propensity or possibility of winning.
Right.
That is not searching for a jurisprudence-driven outcome.
Right.
That is serving their own selfish interests. So they're not looking to determine what is a security. They're looking to win, which means they're not serving the people. They're serving themselves.
Yeah, they should welcome cases like Ripple, where their opponents have the financial resources to fight back. They should welcome it if their mission is to pursue finding out what the truth is, finding out whether tokens are securities. But the fact of the matter is, litigation is expensive, even for the SEC, and they have a lot of resources, but they don't have infinite resources. And so they definitely pick and choose cases based on litigation risk and resource decisions. And so they, if they were litigating one Ripple case after another where their opponents had the ability to put up a big fight, that would be very resource intensive. And, they'd have to cut back on other things. So there's definitely a case selection process there. They don't take every case, even though certain cases would yield more information about what tokens are securities. They don't take those cases every time.
I actually think they should welcome all cases, because Ripple and Ripple's ability to push back is probably antithetical to what Clayton had in mind. But JP Morgan, Goldman Sachs, Citibank, very heavy cash flow, positive entities with significant resources, never have this pushback at all. I haven't seen it once, and I know finance very well. They underestimated Ripple. They know better than to underestimate the money center banks or the, Fortune 50 or Fortune 500. So, Ripple is a matter of bad math from the commissioner's perspective, in my opinion. They don't make such math mistakes when the numbers are significantly outsized. I say this because I cannot lie. I am not unbiased. I am objective, but not unbiased. They have a motive, and Judge Torres agreed with me that in unusually stern reprimand, and I'm paraphrasing, she said that the SEC is more interested in their own preferential outcome than the confines of the law. That might be stern for a judge, but I think she was sugarfooting around. But for a judge, that was a lot. So let me sit back, because it's going to seem like I don't like the SEC enforcement actions.
Well, one thing. So I will, again, I don't want to sound like an apologist for the SEC, because my career is defending people against the SEC. But there is a role for the SEC to play here, and certainly even in the digital asset space, we've seen a number of alleged frauds. And I think investors are served well when the SEC focuses on its core mission, which is policing fraud. It's when they get out beyond that and start expanding their jurisdiction by expanding the definition of a security, expanding the definition of a broker, expanding the definition of an investment advisor, all the sort of gateways into the SEC's world. That's where they start overreaching and overstepping and interfering with the rights of people to participate in the capital markets.
Right. But alleging fraud is a step to that. When you allege fraud, you have a much wider purview of discovery. So when you're going on a fishing expedition and then no fish,
Yeah.
allege fraud, and then
Yeah.
you can take your net and go everywhere you want.
Yeah.
That's the problem.
Yeah. The fraud allegations are not findings of fraud by a judge or a jury. And you're right, Reggie, they open up the ability to go looking at things, and often allegations of fraud are not borne out at the end of the day. So it can be problematic.
Okay, let me stop complaining about the SEC. We have a professional. I'm going to sit back. I have more to say, trust me, but I'm going to sit back.
No, certainly not. Well, I think that's some clarification just for the public, and we really want to use this channel to educate in the crypto space and in the community. And so that's where we're really thankful to have your voice here today. Just for some clarification, the roles that we see in this situation or this space. So it's my understanding, and I'd like you to kind of expand on this, but that Congress is to make the laws, then the SEC would be for oversight, and then but the courts are what would prove or determine that something would be a security. So SEC isn't really who decides what is a security at any point in time. Would that be an accurate statement, or could you help us clarify the roles?
And Nick, if I could drill down on that question even further,
Sure.
You went into great detail about what investment contracts are and what they're not. When Middleton had his initial distribution offering in May of 2017, there were some disclaimers that we were all required to acknowledge, terms and conditions, which said we are purchasing prepaid licenses for software. So there's obviously not a intent for Middleton to act on his own and for the value of our investment to go up. It's just like buying a Microsoft subscription. And we all knew that going in, but somehow the SEC kind of overlooked that. And our attorneys, Kenny Hurst Perry, also went pretty deep into the investment contract issue. Maybe that's a good place to start with the investment contract issue. Why can't the SEC see that there was, in the Ripple case and XRP token holders, there's no investment contract? To my knowledge, the SEC hasn't been able to produce an investment contract, and neither could they in the Veritasium case either.
So maybe to start with Lisa's question, you got it right. Like, Congress establishes the laws, and the SEC is supposed to be the executive branch, and they enforce the laws. There is a space where if it's not clear, and this happens in the digital asset space all the time, if it's not clear whether a particular asset is an investment contract, the SEC's the SEC can speak through many voices. So one of the, you've got the 5 commissioners, they're politically appointed, and then you've got everybody else who works at the SEC. They're all the staff. And so the staff can comment, and it sounds like you all tried to get a no action letter. So generally that's by the Division of Corporation Finance. And a no action letter is by the staff, not the commissioners. And they can say, look, we've looked at your token. If you issue this token in this way, we will not recommend to the commission to bring an enforcement action. So that's one arm of the SEC that can speak in that way. And it's sometimes frustrating to try and get a no action letter. They haven't been giving out a lot, and in the digital asset space, and the ones they do give out are not very helpful. I think Pocketful of Quarters is one of them that's sort of like so obvious it didn't really advance the ball any.
Worth about that much. So
yeah. So but that's one way the staff of the SEC can speak, through no action letters. But another way, and unfortunately a very common way that the SEC speaks on its position about whether a token is a security, is through the enforcement division. So the 5 commissioners have to authorize a lawsuit to be filed, and the enforcement division is who carries that out. And they can do it when it's the SEC's belief that an asset is an investment contract and therefore a security, in advance of, and because you would not be able to file a lawsuit knowing in advance how a judge or jury is going to rule. So that's where there's there's an area where the SEC can be active. They think they have jurisdiction. They think this token is a security. And so they bring an enforcement action. And you don't know whether they're right until the end of that case, when the judge or the jury reaches a conclusion, like they did in the Hashlets private action. So there is an opportunity. There is, in our system, there is an ability for the SEC to act when it's not yet clear, when no judge or jury has finally determined whether an asset. But that is how the process works.
Just sounds a little bit like something out of, the Dukes of Hazzard, like the cop pulls you over and then he goes and changes his outfit and puts on a judge's outfit. You know what I mean? I just think that sounds a little, sounds a little backwards.
Don't get me started on the SEC's administrative proceedings, where in fact they do wear both the judicial robes and the prosecutor hat at the same time as the administrative proceeding, which is a sort of parallel process to federal courts. So the administrative proceedings have a whole host of different and additional problems, but that is
the judges are literally SEC employees.
That's
like
right.
Literally, it's not. So I have a question.
That is so
and if I were to advise a startup, I can't advise legally. I'm not a lawyer, despite my experiential law degree. That's a joke, by the way. I don't have a law degree.
You should.
I would advise a startup, if they were targeted by the SEC, to skip the entire administrative process and go straight to civil, where you actually have discovery powers and you're treated more of an equal, because you're going to have to go through it anyway if you decide to fight. And even if you don't, when you have discovery powers, you can, as Ripple has done, basically defend yourself and hit back before an actual trial starts. What's been uncovered in the Ripple SEC versus Ripple case is phenomenal. A lot of people are calling it the Ripple versus SEC case, because the SEC has been on the defensive, at least from the outside looking in. I haven't went through all the documents. But I'd like to ask your opinion as to why are the settlements and the penalties significantly outsized in the digital asset space, where all the companies are startups, as compared to the greater traditional finance space, such as money center banks, traditional banks, etc. When JP Morgan is fined, they'll find 0.001% of revenues or total assets. I was wiped out with 99.9%. And my story can be replicated almost all over the entire enforcement space, except for one or two companies. And those companies, I believe the settlement went their way because the assets were offshore and the offering was offshore. So assuming what I said is correct from a arithmetic perspective, why would you think that's the case, if I'm not asking you too loaded a question?
No, not at all. So if we're talking about the size of civil penalties imposed, either in
proportionate size relative
proportionate size,
to the ability to pay.
Yeah, one reason, and I can direct your viewers to an amicus brief recently filed yesterday, in fact, on this topic. But the statutory regime for the SEC in determining penalties is amazingly vague, and it's vague in a way that allows the SEC to slice and dice and quantify a penalty in pretty much any way they want to. And that's obviously not good, because then they can impose an enormous penalty in this case where they think it's justified, and a small penalty in this case. I do think there is something. I mean, the big firms do get penalized in large amounts. I think your point, Reggie, is proportionate to their revenue. Say it's not a large amount as opposed to a small actor.
From a financial perspective, large is always relative. So $1 billion to JP Morgan is chump change.
Right.
$1 billion to Kim Kardashian puts her in a negative. Kim Kardashian got $1 million fine, or $5 million, whatever. She got about 5 times her revenue. But think of companies such as Veritasium or many others. Basically, anybody who loses against the SEC in the digital asset space is put out of business.
Yeah. So one reason I would go back to, one reason is the statutory scheme for how to calculate a penalty is hopelessly vague. So that allows the SEC a bunch of discretion in particular cases as to how to calculate it.
Right.
Second,
That's the mechanism. So my question was, and I'm sorry to cut you off. That's the mechanism. My question was the motivation.
Right. So then I think this goes back to a point that one of us made in this call earlier, it might have been you. And that is, okay, I'm the SEC. I'm negotiating with someone who's a small player, who's got no bargaining power. I know they don't have the resources to fight back. I'm going to insist on, I have the mechanism to come up with some arbitrary penalty amount, and they don't have the ability to push back. What are they going to do? They're not going to litigate. And so those settlements tend to have a disproportionately high penalty amount because there is no pushback, which I don't want to toot ICANN's horn, but I mean, that's why we created ICANN. Like, that's not fair. Whereas if
we need more people like you, Nick. We need more people like you protecting the people, because it's obvious to me that the SEC is not looking out after retail. And that's my personal opinion.
Yeah, and the established players with more, I won't go into names, but with more resources and better lawyers, more lawyers can negotiate a proportionately smaller penalty, again, relying on the fact that the statutory mechanism is vague. So
that also goes, oh, I'm sorry, go ahead, Reggie.
I just wanted to add maybe a little more color to the question, because most digital asset space operators would still settle. They'd even be more willing to settle if the SEC, suppose you had $15 million in operating capital. It's not a big company at all. The SEC says, we'll settle for $600,000. They will jump on that opportunity.
Yeah.
Okay. So they're even more motivated to settle for that than they get wiped out for $14.5 million.
Right.
Okay. Particularly since they may have to face private actions after the SEC case.
Right.
But why
then
does
that allows those market disruptors to come in and change the markets, and then their buddies get moved out of their positions. Reggie,
So
you know what game they're playing.
Right. That's where I was heading. I just wanted to see.
Well, that's what Gary said when he was teaching at MIT. He told everybody what they were doing.
He does talk a lot, doesn't he? On video, but
on video.
Yeah.
The penalty amounts also are an opportunity, for better or worse, for the SEC to send a message. So you mentioned the Kim Kardashian penalty. If you look at the penalty that they imposed on Floyd Mayweather 4 years ago, whenever it's the same allegations over the same conduct. His penalty was much lower than her penalty, and you could ask why. I think that if you asked the SEC, they would say, well, because when Kim Kardashian engaged in her conduct, all the other celebrity endorsement settlements had happened, so she should have known better, and so we're going to penalize her more. So, and whether that's true or good or bad, I don't take a position on that, although I have views. But the point is, you can have two different penalty amounts for the same conduct, and one of the reasons the SEC might do that is to send a message.
But it did send. See, that's the case. It did send a message. Let's assume Kim Kardashian is worth about $275 million. I think that might be. I have no idea, but let's assume that's the case. I don't think it's out of the ballpark, whether negative or positive. Okay, they fined her $1 million off of a $250,000 revenue, supposed unlawful revenue. $1 million out of 275 is still de minimis. Okay, she doesn't pose a threat to the money center bank or infrastructure. She's an Instagram model. At the same time, they spent resources doing that. They missed FTX, who they were meeting with, Celsius, BlockFi, 3A Capital, Luna, etc. Okay, and at the same time, you had JP Morgan, you had Citibank, you had Goldman Sachs, etc., whose business models are based and predicated upon breaking certain laws. But it's affordable for them because they're never wiped out. If the SEC were to go after them and find them, say 95% of their tier 1 and tier 3 capital, those banks are out of business, which is the exact same penalty they exacted upon Veritasium. But they have never done it. They didn't do it with Kim Kardashian either. But it seems, and maybe it's my imagination, that if there's something that can threaten that infrastructure, it gets wiped out. upon settlement with the SEC?
Well, again, I'm in the awkward position of defending the SEC here, which I'm not comfortable doing. I think I think because of the ability to push back by well-funded defendants, that's enough of a mechanism. I don't know that you need the to prevent the kinds of penalties you're talking about being imposed. In other words,
Kim Kardashian got fined 1.001% of her net worth, so she didn't need it. What you said would make sense if every entity that couldn't defend themselves wasn't wiped out, but Kim Kardashian and Floyd Mayweather weren't not wiped out.
Yeah.
But it's potential that the entity that holds the patents that can prevent the money center banks from literally moving forward to the next iteration of finance was wiped out. I'm not saying that's the case. I'm just, a wild hypothetical.
Right. Making the observation. Yeah. I don't have an answer for you, Reggie. But
I do, but let me sit back. I told myself I was going to stop.
All right.
For real. Look,
they're good topics.
That does bring up the question about how we clean up the crypto space. Talking about the FTX debacle that's just happened. You've got 1 million unsecured creditors. There's some retail investors that lost their entire life savings in that whole thing. And, there's other bigger entities that lost hundreds of millions of dollars. And as Reggie said, Sam Bankman-Fried was in meetings with Gary Gensler and his staff, just weeks or months before the whole thing fell apart. And, I've been hard on the SEC in my comments, and I think with a little bit of justification, before the digital asset space, you had Bernie Madoff, you had Enron, and where I can see that it's almost impossible to regulate all entities that are under the umbrella of the SEC and protect retail. You would think that some of the resources that the SEC has could be directed towards entities like FTX to make sure that these 1 million unsecured creditors are protected. I mean, that's their first mission on the website. When you look at their mission statement, it's to protect retail. So how do we? Is it a regulatory issue? Do we need Congress to make laws? How do we prevent the FTXs and the Enrons of the world from happening, and how do we protect retail? Nick, how does that happen?
I'm like a kid in the back of the class, like, I know the answer, teacher.
Well, Reggie, if you know the answer, maybe you kick us off, but I'd love to hear Nick's thoughts on that when we.
I want to pose a framework, and I would love to hear Nick's and everybody's opinion on it, because this should be weighed in upon by everybody, not just industry professionals or subject matter pros, but everybody. But FTX happened because of draconian SEC enforcement. SEC, when FTX blew up, many of the politicians came in and said, "Oh no, crypto is bad. We're going to increase regulation." There was no centralized exchange in the states that had an issue. FTX was a Bahamian entity, number one. And number two, I would like to correct the terminology, because crypto exchanges are not really exchanges. They were called exchanges because that term was given by a cypherpunk or reporter who doesn't really know, the mechanics of finance. But, Coinbase and Kraken and Gemini are really broker dealers. Okay, I'm going to not say a securities broker dealer, because I am not going to state that they're securities, but there are broker dealers in the technical
Maybe a commodities broker dealer.
Well, I'm not going to get into what kind of broker dealers there are, but there are broker dealers and not exchanges. If you look up the technical definition and the mechanical makeup of an exchange versus a broker dealer, you'll see the exchanges are brokers and dealers. Okay, slight nuance, but I want to make that the case. Let's say the SEC took the budget that they put in going after Kim Kardashian, the Instagram models and Veritasium, and just pick one other entity.
Library.
Ripple library. No, Ripple, because Ripple said that they reserved just over $100 million for legal fees. Okay, the SEC did a preliminary investigation first, and they were the moving party, so they spent more than 100 million, most likely. So let's say 120 million, 115 million. I think that would you consider that fair if Ripple paid 100 million?
You mean a penalty or in legal fees?
No, in resources.
To defend themselves. Are you talking about?
Yeah, well, Ripple already, the CEO of Ripple said that they've allocated over $100 million for the SEC case.
Right.
The SEC was a moving party and did the preliminary research beforehand, presumably. So I would expect their resource spend to be just over 100 million.
Oh,
okay.
Seems high to me. They've got.
Okay.
But anyway, keep going with you. I don't know.
Okay. Well, and the way I calculate it is, when they have a lawyer, a paralegal, they pay an outsourced consultant. Everything they pay is part of the resources. That's taxpayer money. It's unlikely they're going to pay less than Ripple when they're the moving party, and they already did the the investigation. So by the time Ripple even finds out about it, the SEC already started spending capital. Okay, that's just the way I'm looking at it. But let's say it's 80 million. Let's say I'm wrong, and they spend 80 million. Ripple spends 120 million. Out of that $80 million, take 10% of it, which is only $8 million. Create a set of clear guidelines and rules. And if you don't know how to do it, look to Japan, look to Singapore. Okay, look to the Bahamas. Look to almost everywhere except the US. Create a set of rules, regulations, and guidelines. Get community feedback. Codify them, send them to Congress. Okay, create laws, welcome all these businesses onshore. And as a broker dealer that holds company entity and client assets, create liquidity minimums, create tier 1, tier 2 capital minimums, okay, and solvency requirements. By doing that and audited financials, even as a private entity, FTX could have never happened, because the way FTX imploded was very, very easy to see. They created an arbitrary token. They gave it an arbitrary price, and they said this token is used to discount trading fees. Well, if that's the case, it's very easy to declare that token. Let's say FTX did $800 million worth of trading fees for the year. Okay, the token gives you a 10% discount. That is $80 million annually. Discounted out 7 years, back to the current, you get roughly aggregate value of 600 million. That's how much the entire pool of FTX tokens are worth. Not advanced math. Somehow FTX used that for tens of billions of dollars worth of collateral. That would have never happened if you just brought it on shore, did everything by the book. There's a clear line. That's legal. This is not legal. And then everybody would rush to the U.S. market, because this is the biggest, deepest, most liquid, and the wealthiest market in the world when it comes to finance markets. Instead, the SEC decides to purposely blur the lines, purposely not give rules and regulations, and then regulate by hitting people over the head, enforcement versus rules and regulations. That those businesses rush offshore. 96% of transaction revenue occurs offshore, and yet they still reach into the U.S. and affect the U.S. And even if they don't trade directly in the U.S., they lend and borrow and commingle with U.S. companies. When they break, everything else breaks, because fundamental analysis, it doesn't pay as well as regulatory arbitrage. I'll land my plane there. Tell me if you think that plan might work.
I'm going to agree in part and disagree in part. So where I'm going to agree is the lack of clarity that the SEC is partly responsible for, along with the other agencies in Congress, has driven people offshore to the Bahamas and elsewhere. And to be sure, with more clarity, there would be more incentive to bring things onshore. So I totally agree with that. The lack of clarity has pushed things beyond, or made it very hard for the regulators to reach entities that are offshore. But I do think there's this notion that because I'm not in favor of increasing regulation as a means of protecting investors, because I don't think it necessarily works. So if the offshore entities had been brought onshore, the two examples that Trey gave of massive frauds that occurred here onshore were Madoff and Enron. Well, Enron was a publicly traded company, highly regulated, required to make public disclosures, and yet they committed a massive fraud. Madoff was in the investment advisor and broker space, super regulated, committed a huge fraud that, in hindsight, probably shouldn't have been that hard to detect. So I agree with you. If the SEC and Congress and the other regulators had been more clear, there would have been a greater incentive not to go offshore, and I think that would have benefited and reduced the probability of a fraud. But I think also the notion that just because you're a regulated broker or investment advisor or public company precludes the possibility of a bad actor committing fraud, that's where I would push back a little. Fraud will still occur even if you're here in the U.S. Bad actors are hard for anyone to detect, and having worked at the SEC, it's always easier to find bad actors once someone's pointed out the fraud. Then oh, well, that was obvious. It's pretty hard to detect in advance. So that's the only place I would push back on, is even if they were here, they still probably,
Well,
Go ahead, Trey.
I was just going to say the difference between the Enron and Madoff in its instances is that they were acting through a banking system. Don't you think it's easier to regulate something that's on the blockchain that everybody can see?
Hey, if you could increase transparency, and if blockchain technology helps increase transparency, that helps everybody. If I'm able to, if Joe Public is able to go look and sleuth out potential fraud, now you've really empowered sort of like crowdsourced detective agency work that's outside the regulators. I think that would be an innovative solution to fraud detection.
Yeah. Well, FTX happened because it was centralized and there was no transparency. Evidently, they made a back door between Alameda Research and FTX, where Alameda Research was making big bets that with other people's money that fell apart. So we need the Veritasium truth machine in our financial system.
Well, let me jump in, because I agree with 75% of what you said. No, I disagree with 75%. It's been too long. That 1 minute affected me. My memory is very bad. So Madoff was an issue of regulatory capture. So it didn't have to do with anything with regulation. It's actually the opposite. Madoff was a regulator. He headed FINRA, if I'm not mistaken. Okay, so if you head the regulator, regulation is not the problem. The fraud was in the regulator. You had the perpetrator of fraud heading FINRA. Now, was he the head or did he serve on the board? I can't remember. But either way, he is much too high. Go ahead.
He had a history of being the head of FINRA, not at the time he was running. So I will agree with you on the regulatory capture point. But
okay.
Fried could have achieved the same thing, I suppose.
Okay. So Sam Bankman-Fried, and I'll get to that because my expertise comes in where I can see this stuff coming. And I'll give you an example right now, or right after I finish this point. So Enron was an example of, they were basically a shadow banking entity, but they were not treated as such. Okay. If you examine all SPVs, special purpose vehicles, and offshoot vehicles, and you went through with a fine tooth comb, and they had liquidity and solvency ratios that they had to report. Okay, just reporting that allows people like me to go and take a look at it. And the market will read this out because they'll just get shorted. And, when you short something, you lose a lot of money when you're wrong, but you make decent money when you're right. Same thing would have been easy with FTX. I just explained quickly how to value FTX tokens and BNB tokens, the same thing. But because nobody ever takes a forensic look at it, unless it's a market participant who has capital and already knows what they're doing, they get away with it. Okay, and I'm not saying Binance is doing anything wrong, but it is very easy to value these Binance and FTT tokens and find out if they're overpriced, underpriced, or marked properly to market. If you're going to hold client capital on balance sheet, okay, you have to be subject to auditing, liquidity, and solvency ratios. And if you don't want that, that's cool, but don't act like a bank if you don't want to be treated like a bank. And I'm by far not super pro regulation, but I'm realistic. Imagine if the money centering banks and the investment banks did not have to report their solvency, liquidity, and capital ratios. Imagine what would happen. Look at Lehman and Bear Stearns and Washington Mutual and Countrywide when they did have to report them. And I'm an expert on this because I told everybody that all those entities were going bust. I put out 30-page reports in each and every one of them. And within 6 to 9 months of the report, or 3 to 9 months, they all popped. It's not hard to see, just look, but you can't look if it's not reported. Even when it's reported and reported improperly, you can see vagaries over time or inconsistencies where they're lying. It's impossible when you have a totally private entity offshore that doesn't have to report anything. And even then, I can still tell you that the FTT tokens were overvalued. Coinbase right now, from an economic perspective, rehypothecates client assets. And the CEO was in the Wall Street Journal and Twitter clearly saying that they hold all assets, client assets, on a one-to-one basis with reserves, and that they do not leverage client assets without consent. And I went through USDC user agreement, and I did not see any requests or consents for hypothecation or for rehypothecation. And they rehypothecate by assisting Circle to issue USDC. So you give Circle and Coinbase $100 million. They give you 100 million USDC. That 100 million USDC is invested for the profit or gain of Circle and or Coinbase. And you get these tokens you could trade freely. But Coinbase is now going and offering to reinvest the USDC for additional yield. But wait a minute, you have $100 million of collateral hypothecated. You get these tokens, they relend the tokens. So now you have 2 loans with only 1 set of collateral. So what happens if someone pulls that first set of collateral back? That second loan is now 100% unsecured. And I don't see anywhere where that was requested. This is simple fundamental analysis, stuff that is no longer done, particularly in the digital asset space. Easy to find. All these companies, if they want to access these markets, come on board, submit the minimums, give audited financials. I think the regulatory requirements should be much lower than a public company. Don't get me wrong, but audited financials, liquidity minimums, solvency minimums. Voila. And let the market read out the fraud.
Well, that's definitely an area I think we're in total agreement, Reggie, that let the market figure out the fraud, I think, is probably part of the answer here. The SEC, so I'm nervous if we're saying we should just increase the regulatory obligations of entities and hope that that will prevent the next Madoff in the digital asset space, because I don't think that's going to happen, or it won't happen enough. So if there is a way to crowdsource fraud detection, I think that's the way to do it. And I think, when people create investment opportunities, they can choose to be transparent about it, or they can choose to make it a black box. And those investments that are transparent should be more attractive to investors because they're susceptible to crowdsourced fraud detection and more likely to be on the up and up. If someone's presenting something as a black box, if I'm an investor, I would shy away from that. There's just no transparency. I think we're converging on an area of agreement here.
Yeah, I mean, here's a better idea. You don't want to report solvency and liquidity minimums? No problem. Do it the way it's supposed to be done. You're holding digital assets that should be fully decentralized anyway. Now smart contracts hold the capital and not a centralized entity. And now you're not exposed to their counterparty risk, their operating risk, or their credit risk.
Yep.
Which is the way it's supposed to be. I hate to be harsh, but unless you got into this business yesterday, if you lost money on BlockFi, Celsius, FTX, because you had capital there that wasn't waiting for order fill, you had it coming. The whole purpose of digital assets is self-sovereignty and controlling your own assets. So if you rip it off of a chain and you send it to somebody else and give them access to your private keys, and you take a loss, what I call USDC, since you are giving money, you give $100 million in, You get $100 million of USDC out, but you get no yield, no return whatsoever. But you are taking the risk of Circle, which is a junk rated company, not rated, a junk level company that had a going concern from the auditor just a year and a half ago. You're taking what would be called in business school parlance as return-free risk. Not the risk-free return, but return-free risk. You're getting all the risk and zero the return. What is the purpose?
That's the narrative that I see playing out, is that this is the, as much as they're trying to blame this on crypto, it's actually the education of the legacy financial system being played out in the crypto world.
Exactly.
Because the Bitcoin was created for people to have, to stop the double spend, the rehypothecation that you were just talking about, those kind of situations, for people to hold assets in their own possession and to escape this legacy financial system that's so corrupt. And instead, we went through this period of time where the crypto world went gaga over number go up. And you started going, I mean, Reggie, we were in Miami at blockchain, at the Bitcoin week conference. And it looked like a legacy financial conference. It didn't look like a crypto cypherpunk alternative event. They were trying to look like banks. And it's like, you guys lost your way. And now it's a hard lesson, but we're coming back to those core values, and the people are having to learn that hard lesson of hold your assets in your own possession. Stop. The banking industry is crooked and not looking out for the individuals. And so I think it's this tough lesson, but that's really what we're being taught, ironically, about the financial system. I just hate that crypto is being blamed for that. I believe that the powers that be, are going to point the finger. They are going to point the finger at crypto. Reggie, you did such a great job explaining in that your Thanksgiving video about how the FTX scam and how that all played out, and what the information about what Coinbase is doing with rehypothecation and all that. And I think that the general public is going to say, oh, that crypto thing is bad. And then I believe they're going to use that to tell people, oh, but don't worry, you can trust the CBDC because it's backed by banks and you'll be safe in a CBDC.
I was going to say, they're going to say the crypto thing is bad, but the federal government is going headlong into the CBDCs.
Right.
I mean, they're getting into it.
Yeah, but really the FTX thing was just a shell. It wasn't real crypto. It was a shell of a company that was really just moving legacy finance back and forth.
Let me see if I can help you out with that.
Thanks.
FTX and Coinbase and all the exchanges are not really exchanges. They're really broker-dealers. And when they hold capital in mass and act as a principal, in other words, they trade for their own account and they start lending, they're now shadow banks. A shadow bank and a broker-dealer sounds a whole lot like regular banks. JP Morgan, Citibank. The difference is, and I'm going to defend the banks, you're going to hate me. Those banks are regulated for statutory minimums, et cetera, et cetera. But when they do something wrong, they're never wiped out by the SEC.
Right.
Okay, so either use the decentralized mechanisms that work, and it literally eliminates counterparty and credit risk. Literally, you still have operational risk, you still have execution risk. Okay, but you don't have counterparty and credit risk, which is a risk that's taken everybody out, by the way, this last year or two. But if you push that to the side, you simply have the system that everybody says they're running from. They're really running to it. FTX didn't get that big because people are trying to go decentralized. They got that big because everybody jumped into a shadow bank and a broker deal.
Yep. You are right. You are right. Oh, so where do we go
So,
from here?
so
I need
going
someone to
an
disagree
hour,
with me so I can argue.
going on an hour and 20 minutes. Nick, how can we help point people in your direction? If somebody wanted to get a hold of you for an issue that they're dealing with, how can they reach you?
Well, the easiest way, if it's something that a private law firm could help, is I'm at paulhastings.com, easy to find there. And of course, the nonprofit is icanlaw.org. And, we're looking for areas where we could be helpful. We're looking to grow our resource base, obviously, or nonprofit. So we're happy to talk to anybody about any of these topics, on a casual basis. So.
Yeah, well, we need more Nick Morgans of the world. We need more ICANNs of the world. In conclusion, I think that the crypto space is, due to regulate itself. We need to get to a point where we have business models that eliminate this counterparty risk that we're all encountering right now. And I think that very soon we're going to be moving into the space where we see that happening.
Absolutely.
I would
Thank you
hope so.
guys.
That sounds good. I would hope so.
Yeah. Well, hopefully we get the Veritasium Truth Machine back up and running and in the forefront of this in this currency model, and we have a bright future ahead. So thank you guys all for joining us.
Thank you for
Thanks,
having
Nick.
me.
Thanks, Reggie.
All right.
Goodbye.